morning from India. My name is Kumar. I'm the founding Vice Chancellor of OP Jindal Global University. Good afternoon to our friends in Southeast Asia. Good evening to our friends in Australia. And good afternoon again to our friends in Hawaii as well. It is such a pleasure for me to welcome all of you to this third day of the Global Virtual Conference on Reimagining and Transforming the Future of Legal Education and Law Schools. We are, of course, on the 21st thematic session of this conference on the theme Teaching, Mooting, and Advocacy Online. When OP Jindal Global University conceived of this conference, little did we know that this collective consciousness of humanity that has been shaken by the COVID-19 crisis has brought us all together to discuss on issues that confront our present and indeed our future. We couldn't have had a better group of people who have assembled here today in this panel to discuss about issues surrounding teaching, mooting, and advocacy online in a larger context of judges and lawyers working even in courts which have gone virtual. I have great pleasure in welcoming Honorable Ms. Justice SABRINA MCKENNA, Judge of the Supreme Court of Hawaii in the United States of America. We have with us Professor Nick James, Executive Dean of the Faculty of Law, Bond University, one of the leading law schools in Australia. We have with us Dr. SURAT Singh, a very dear friend and a mentor and senior advocate in the Supreme Court of India, a distinguished graduate of both Oxford and Harvard universities. We also have with us my colleague, Professor KARAN, Assistant Professor and Assistant Dean, Jindal Global Law School, one of the core organizers of this conference as well. And I'm also grateful to my colleague, Professor SARBANI, who is a professor at Jindal Global Law School at OP Jindal Global University, who has agreed to moderate this panel. In many ways, this is a global panel, not only because of the organizations and institutions that we are representing, but more importantly, from the locations that we are. Although SARBANI teaches at Jindal, she is now speaking in this panel from Canada. Such is the global engagement that has happened, and COVID-19 has created both a challenge and indeed an opportunity. With those words, I'm going to hand this panel over to SARBANI for taking this forward. Thank you very much.
Thank you, Raj. A very warm welcome to the distinguished panelists participating in the discussion today. The theme for today's discussion is Teaching, Mooting, and Advocacy Online. Mooting and advocacy play an important role in legal education, both for students and faculty, since it offers the closest experience to a courtroom. There are medieval origins to mooting, which can be traced back to the Inns of Court. Apprentices had to undergo mooting for many years before they could actually start practicing before the courts. Cases were discussed after dinner at the hall of the inn, followed by mooting sessions with a bench and apprentices assuming relevant roles. The essence of mooting has not changed much since then. Students continue to simulate the role of advocates before a bench, making arguments based on a hypothetical case. Mooting requires multiple skills: logical argument, the ability to think on one's feet, rhetoric, and a display of proper court etiquette. Mooting is also a mode of contestation between law schools through many prestigious moot court competitions. Mooting requires the use of a defined physical space, and it is also a time-bound activity. As legal education moved online during the pandemic, the conduct of mooting sessions as an essential law school activity has become challenging. Mooting sessions in law schools, as well as prestigious moot court competitions, has shifted online. But online mooting is heavily reliant on technology. Such reliance has prompted many mooting events to rewrite mooting rules so as to accommodate disruptions caused by power and internet disruptions or software and hardware failures. The mooting room has lost its confidentiality, as well as the challenge of being extempore. There can also be privacy, intellectual property, and cybersecurity issues. Thus, it is important to reimagine the concept of mooting without letting the spirit of the activity fade. Such reimagination is appropriate since during the pandemic, actual courtrooms have also had to shift to online platforms. There are many questions that law schools face regarding teaching mooting and advocacy online. For instance, is it possible to recreate the same learning experience in online platforms that mooting in physical moot rooms offer? What aspects of physical mooting might get lost when the activity goes online? can essential mooting skills still be taught? Given the pedagogical objective of moot courts, is the loss of physical space significant? So these similar questions are going to be the subject matter for deliberation by the learned panelists today. The discussion will take place by my asking questions which are of interest to the panelists, and each speaker has 3 to 4 minutes in which to respond. We have to sum up 10 minutes before the session ends so that there can be some questions from the audience. So the first question that I would like to ask, I would like to pose to Professor James. Considering that mooting requires public as much as public speaking as much as debates, why do law schools stress mooting over other activities? How are the skills developed through mooting different from those obtained through other public speaking activities? Considering that historically, apprentices had to perform at moots for many years before taking up advocacy, can we infer that the skills gained in mooting translate into relevant experience before the courts? Professor.
Thank you very much, Professor. It's a good question to start the conversation, a nice general question about the value of mooting generally to law schools and to law students. So initially, a little bit of background. So I'm the Dean of the Faculty of Law at Bond University in Australia. And here at Bond, we try very hard to promote a strong mooting culture. And we're able to do that because, one, we have a very low student-staff ratio, so we have very small classes here. And we're able to use mooting as a teaching and assessment tool in many of our subjects, as well as supporting our students to participate in international mooting competitions. So all of our students experience being required to moot and being assessed on their mooting skills periodically throughout the degree. And the other reason we have a strong mooting culture is, as a private university, we're very well resourced. And so we're able to support our teams to travel and compete internationally as well as domestically. Now, the reason why we embed mooting as a teaching and an assessment tool throughout the curriculum, which goes to the question that you asked, is because in our view, there are very few better ways in which a student can be called upon to demonstrate their understanding of the law and their ability to exercise practical legal skills. So while it's true that mooting does go a long way towards preparing law students for courtroom practice, the value of mooting goes far beyond that, because it teaches students the importance of researching their case, presenting their arguments articulately and persuasively. It refines their oral communication skills, and it teaches them that very, very important ability to think on your feet. And that's something that debating, in the general sense, doesn't do. Debating can be very well rehearsed, but mooting, there is nothing like standing up with your case prepared and having a judge immediately start interrupting you and challenging you and forcing you to rethink your argument and come up with a persuasive argument on the spot. And even if the law student never goes into the courtroom and never practices as a member of the bar, the value of learning how to moot is going to be beneficial no matter what they do. So that's why we embed mooting wherever we possibly can in our curriculum. It's an extraordinarily valuable teaching tool.
See, being both a Supreme Court lawyer and teacher, the mooting I found, as Dean James rightly pointed out, extremely effective tool to communicate competence, confidence, communication, 3 skills, and understanding the concept. Because as he has rightly pointed out, the moment you enter in the court, whatever written is already there before the judges, and they start asking questions. So responding to them makes all the difference whether you will win the case or not. Particularly more so at the higher level, like Supreme Court. In special leave petition, we get 2 minutes, 3 minutes. There are 70 cases listed in a day. So if you are well rehearsed in mooting at law school, it is extremely helpful, because then you can think on your feet and you can respond spontaneously. So mooting as an effective tool of teaching is best indicator whether a student has likelihood of succeeding in legal practice. So Dean is absolutely right, and that's why, and mooting can be done online. Like for example, when I was teaching my course, Lawyering in Supreme Court, now idea was how to show them how to argue. So I asked them online that supposing if you're Attorney General of India, how you will argue, or if you're defense lawyer, how will you argue? And the students did that on line, and I was able to give feedback to them there and then and demonstrate them that how it could have been done differently. So yes, mooting online is an extremely effective tool.
Thank you, Dr. Singh. My next question goes to Honorable Justice McKenna. Courtrooms across the globe have undergone a digital transformation due to the pandemic. What are your views on the effectiveness of online hearings? How challenging has this transformation been?
Thank you, and aloha to everyone around the world. It's really an honor to be able to join you today. Yes, we have started in May, we started doing our oral arguments online. You know, I think March and April, we weren't sure what was happening. By May, it was very clear that this situation would continue for a while. So we started doing online oral arguments. There are 5 of us on our court, the Hawaii Supreme Court, which is the highest court of one of the 50 states in the United States. And our oral arguments, our hearings are different from the, for the high courts or the India Supreme Court, where it, as the advocate has said, it's 2 to 3 minutes. We have arguments that last for 40 minutes to about an hour, and we give 20 minutes or 30 minutes to each side. And so our court is known as, I think, to be what we call a hot bench, which is a bench that starts asking a lot of questions fairly early. And as the advocate has said, it is for the attorneys to argue in front of us. So, you know, we had to make some adjustments because instead of sitting in the courtroom for the 5 of us, because we need to socially distance, we do this from our chambers. And I do it from here. This is my chambers. The only difference is I have my robe on. The Chief Justice is in the courtroom, but the remaining 4 of us are in our chambers with our robes on. So how do you ask questions? What we have gone, since we only have 5 of us, we have just gone to the Chief Justice, sees all of us on the screen, and if we have a question, we raise our hand, and the Chief Justice calls on us and says, Justice McKenna has a question. And that's how we do it. I have found that the challenges have also created opportunities, as Vice Chancellor Kumar has said. What we have found is that this really works for appellate oral arguments. Our trial courts, for example, our district court has also gone to Zoom hearings for minor matters, such as initial appearances in criminal matters, or for our traffic cases. And ironically, for our traffic citation cases, our experience now in district court is that we have a much higher percentage of people that actually appear, because it's so much easier to appear via Zoom than it is to get on a bus or drive and park and get into a very crowded courtroom, go through the security line. It takes a long time, but on Zoom, people can just appear and say, yes, I admit, or I deny, or the prosecutor will say, if you admit, we will go ahead and reduce the fine. Do you want to, just pay the fine today? And people can take care of the matter. So the bottom line is, I think that this has created opportunities. especially because we are an island state. We have several major islands, and we've had oral arguments in our courtroom, which means that if we have cases from other islands, the attorneys would have to get on an airplane, fly to our island, rent a car, or have somebody pick them up, drop them off at our courtroom. It takes an entire day to do a 1 hour or 40-minute oral argument. Whereas now, all of the attorneys are doing this from their own offices, and if they're from another island, they don't have to travel. And one of the real advantages also that we've had is that when there's 5 of us, and our law requires that there be 5 of us hearing each case. And for example, if one justice has retired or has to recuse due to a conflict of interest from a case, we have trial court judges, our higher level trial court judges come and sit with us. But up until now, it's only been judges on this island that have been able to sit with us. But because we're doing it via Zoom now, we can have judges from the other islands, which is a wonderful educational experience for judges, because I, as a trial court judge, also used to come up to the Supreme Court sometimes on these cases that justices were recused. And I learned a lot about how the appellate courts view my cases as a trial judge, the standard of review, the things that the appellate courts are thinking of, which help me as a trial judge make better decisions. So I do think that this remote experience has provided opportunities for appellate arguments and for minor matters in the minor matters, or for initial experiences or traffic cases. However, I do not think that this is something that really works when judging the credibility of witnesses is at stake. And actually, for example, you probably know that not only is there a federal constitution, but each of the 50 states have our own constitutions. Most state constitutions have the right of confrontation in our constitution. Under Hawaii law, under the Hawaii Constitution, in criminal cases, the right of confrontation means face-to-face. This isn't necessarily true of all states. So some states have been doing criminal cases online. Our Constitution requires that a criminal defendant be able to confront the witness face-to-face, which means that we cannot do criminal trials online. So we have a major backlog of criminal trials, and also jury trials, which is a big issue. But we have we are now starting to do our criminal trials and jury trials live with appropriate social distancing and measures, and we have started doing that. So I think it's working.
Thank you. Let me get to the third question, and I would like to address this question to Professor James as well as Professor Lahan. So mooting is the most authentic form of courtroom experience that law schools provide to students. The mode of hearings and mooting during this pandemic has had to change. How should law schools reimagine the way in which to conduct and mooting, and what support should they give students, should universities or law schools give students in organizing virtual moot courts?
Conveniently, last night, my faculty hosted a special dinner for all of our mooting teams who've been participating in the last year. And so, I couldn't have asked for a better way to prepare for this conference, because I was sat at dinner at an event with dozens of students who have, over the last 12 months, experienced online mooting. And I told them I was coming to this conference, and I was asking them lots of questions about their experiences, and heard a lot of very positive stories about the transition that was made to online mooting, because it took many people by surprise. When the pandemic hit, many of our students were already in teams preparing for competitions. So some of our students experienced the disappointment of competitions being cancelled very early in the pandemic, but then having to make the transition from what was proposed to be a face-to-face mooting competition to an online competition, which often meant delays. But generally, students who participate in competitive mooting are extremely resilient anyway. Mooting, as we know, is a very, very difficult and challenging experience. And so these students are quite intellectually, if not physically, tough in order to withstand the pressure of mooting. So they were able to adjust relatively quickly. I think one of the hardest challenges was the enormous disappointment that they experienced in not getting to physically travel to other jurisdictions and other places in order to compete. But once they got past the disappointment of not going to The Hague or Washington or Beijing in order to moot, they realized that the online mooting was actually providing them with some extraordinary experiences and opportunities to, while they couldn't travel to one other country, they got to peer through a window into the lives of students and judges and academics all over the world, and see what their backgrounds look like, and have conversations and learn about other cultures, which was wonderful. In terms of helping students to make that transition, I think there's a few points. One is that, as I think the judge has already made the point, that any adjustments made on the part of the courts is in many regards temporary. So that's the case here as well, that while some processes have moved online and are likely to stay online, many of the more important trials, the courts are keen to get back to face-to-face as quickly as possible. And so we're not talking about a radical transformation of mooting towards only having online mooting. What I suspect is going to happen, as will happen with the courts, is that where appropriate, things will be done electronically and virtually, but wherever possible, the more important matters and the more prestigious moots will be held face-to-face. So now law schools have an obligation, I think, to prepare students for both styles of mooting. And when it comes to, while of course we have a lot of experience with supporting students with the traditional face-to-face mooting, in terms of helping them with virtual mooting, apart from the obvious obligation to ensure they have, an excellent internet connection and access to equipment and cameras and quiet spaces in which to actually engage in the mooting, where they're not going to be interrupted by other students or by academics, but also training them in the differences between face-to-face and online mooting. And I think we're going to explore that a little later in the panel discussion, because what's come through is that there are some very, very important differences between the way one moots and advocates in person and online. And I'm looking forward to exploring those differences.
Great. Mr. Latayan, would you like to add anything to what Professor James is going to say?
Yes, thank you, Professor Singh. Thank you so much for this opportunity. Good morning to everyone. So I'll try to answer this question from the perspective of being a mooter, though I have been disconnected from the mooting circuit for a while now. But if I put myself in the shoes of a mooter who's going for a moot court competition during the pandemic, so the biggest challenge that I would face is basically how to deal with the absence of the courtroom theatrics. So one of the major aids that I had available to me was a sense of the bench, whether they are with me, while I'm arguing a case, whether they are disconnected, whether they agree with me, disagree with me. Reading that, reading the bench, which is an integral part of mooting, is something which I feel would be of a challenge, specifically, on the online platforms. And as already indicated by Justice McKenna and also Professor James, there are certain critical, physical confrontations that require a face-to-face conversation, like reading the witness. That touch of the cheek, that scratch behind the ear that you can't see on the online platform is very important for, like in India, we have cross-examinations. There are trial advocacy moots where, these things matter. Like students are trained to kind of pick on these actions in the courtroom. So having said that, there is a challenge, and I feel mooting as a core academic activity, it needs to continue. So online mooting is a good means of continuity, but in a way, having having mooted in the past, I would still want mooting to be a physical experience. But with respect to the suggestions or the training that is required with respect to online mooting nowadays, the biggest challenge I feel is that, when you're not in the courtroom, you can't move your hands, you can't be animated behind the dais. And that kind of makes this disconnect apparent. So I would suggest that, if I am training a moot team, I would be more stressing upon the speech modulation, which now needs to be even more than before. It's through their speeches that students need to summon the golden age of radio again, where the listener can close their eyes and still feel connected to the listener, to the speaker. So that is I think is a bigger challenge. Also, it's a tangential point, but I would still want to make it. Court etiquettes is a big thing, but when the court transforms onto an online platform, there are certain additional etiquettes and mannerisms that need to be taught. For example, there may be a voice lag, right? The speaker who's speaking on the other side, you may not be able to hear him in real time. So, understanding those dynamics, ensuring that, you understand your environment and surroundings, I think that's an added responsibility that needs to be taught to the students as to how to conduct on an online platform. Thank you so much.
Thank you. So just taking off on the points that Professor LATAYAN made, and I think also Professor James, there are some kind of challenges to online mooting, which kind of makes it different from the physical moot courtroom. So this question I would like to ask to Dr. Singh. So being able to observe witnesses in person forms an important aspect of physical courtrooms. High resolution videos can conceal the minutiae of facial expressions, and a network lag can be misinterpreted as a hesitation to respond on the part of the witness. So what level of training should law students undergo to prepare for the needs of online hearings? Will online mooting be transitional, or actually a necessity for managing virtual hearings that may possibly represent the future? Through what other means should law schools engage in teaching advocacy online?
Professor Singh, thank you very much. See, whether it's mooting, teaching, or advocacy, online or in person, the true test is effectiveness. And effectiveness means the purpose for which the activity is done. Say, for example, as a lawyer in court, our purpose is to persuade the judge to our way of thinking. Same thing is required in mooting. Now, and apart from, so three qualities are needed, as I say, of a top lawyer. One is competence, of course. Second is communication, because one might be having a clarity in his head or her head, but unless it is communicated, Justice McKenna will agree with me that unless it reaches the judge, it is not effective. So competence, communication, and connecting. Connecting means able to communicate, able to connect with whatever the judges are saying, because if you are not addressing the questions which judges are having, then it means you are just talking to yourself. So it is very important that students have that sense that these things are to be communicated. And that's why, as LATAYAN said, that you will not see the interaction of judges online. Now that's very important, because arguing is a two-way traffic. It is what you say and how the judge respond, and the judicial decision making is an interaction between the advocates and the judges. So now, for example, what I did this time when I was teaching a course of lawyering in Supreme Court at Jindal University, apart from producing the arguments for both sides, petitioners as well as defendant, we also gave an assignment to write a judgment so that they understand that how the arguments are perceived. So we gave a Supreme Court case and we said that supposing if you were to write a judgment, write a 30-page judgment, these are the arguments on both sides. So they get the sense also that apart from the advocacy, there is a target audience, that is the judge or judges, that how they perceive it and how do you address their questions and concerns. As Justice McKenna rightly said, that material is already there. 2 minutes are in special leave petition in Supreme Court. But when there are final arguments, Justice McKenna, even in Indian Supreme Court, we get not only 30 minutes, but even days together. And then judges ask the question that, okay, Mr. Singh, you have given this interpretation. How about this? What are the consequences in scenario this? So all this interaction is very important. So the test, whether in online or in person, will always be effectiveness. And as the theme, overall theme of this conference, Professor Raja said, reimagining and transforming law schools and legal education. So what I would say, that whether it's online or in person, the substantive aspect will always remain. For example, the contents, effectiveness. So 3 things I emphasize: competence, communication, and care. Teachers should care, judges should care, advocates should care about the objects for which we are engaged in. And one transformation, if I can suggest, is that instead of teaching at law school, because I am both a Supreme Court lawyer and an honorary professor at Jindal University, so the vision of law school legal education, instead of just training them just as a lawyer, training them as how to be great judges, how to be great lawyer, how to be great jurist also. Because at least in India, we need more reflections the way law works. And we have some very distinguished jurists like Professor Rajkumar, Professor Bakshi, of course, earlier Nani Palkiwala. But on jurist, reflecting on the role of the law is very important. And there I say that instead of just focusing on black letter of law, focusing on big picture of law is very important. Instead of just focusing on lawyer's law, focusing on what I will call statesman law, means how law is applied by legislature, executive, judiciary. So overall picture of the law in transforming the society is very important, which is to be communicated whether in person or online.
Thank you, Dr. Singh. The next question is one that I think Professor James and Professor Latayan can again address. Some of the world's largest mooting competitions, such as JESA, has now moved online. Will online mooting provide students with the same set of skills as the traditional format, or does it develop new skills? Will the skills, these new skill sets which are gained through online mooting, be relevant in a physical courtroom post-pandemic?
So this is, we're going to sort of look more closely now at the differences between online mooting and face-to-face, and whether the new skills that the students are going to be having to learn in order to compete in online moots is going to be useful to face-to-face. Just starting with that final point, I think the ability to communicate persuasively and effectively, thanks to Dr. Singh, via online media is something that all lawyers are going to have to do going forward. It's the reality of the legal workplace is that a significant proportion of their work, whether it's communicating with clients or with colleagues or with members of the judiciary, is going to be via this screen. So I think any skills that they develop as a result of online mooting are going to be useful in legal practice from now on, even if they aren't necessarily directly relevant to face-to-face advocacy. So what are the differences? And this is what I picked up from having conversations with numerous mooting students who have had the opportunity to compete in face-to-face moots and online moots and are very conscious of the difference. And it picks up on something that some of the earlier speakers have said, is that when you're advocating online, because you can only see part of the body and often only the face, a lot of the normal body language and performativity that advocates engage in the classroom is lost. You don't get to walk around and wave your arms and so on. But you do still need to perform. And the fact that the camera is often very close to the face of the student and, of course, the bench means that, as has been pointed out, micro expressions, performance in the face and in the voice become extremely important. And the students I spoke to were expressing gratitude for being given the opportunity to develop a very new style of advocacy where it's all about having an animated expression and putting emphasis into the use of particular words and performing in the face. And again, I think that is going to be, I think being more mindful of performance on that more micro level is, I think, going to be useful even in the face-to-face courtroom or classroom. But that is something that's going to be useful in many forms of legal practice. The other big difference, jokingly, this was brought up by a few female students who said just how wonderful it was to be able to moot and not have to wear high heels, to just moot in slippers and socks and not only have to really prepare this part for the performance and be quite relaxed in the off-camera parts. And they also talked about how mooting from a safe space, from the campus or from home even, is helpful. It's kind of reassuring because mooting is difficult enough without also having the stress of traveling to somewhere strange and unusual, which is a great experience, but it's also stressful. And so online mooting can be less stressful in many instances.
If I may, one sentence from practical experience. I was arguing before the Supreme Court and Chief Justice said, Dr. Singh, you are staring down at us, so be away from the camera.
Actually, just on the point about cameras, another point that the students made was that they feel that online mooting is fairer in the sense that everybody sees the same angle. So that when students are competing in a courtroom, the students who are advocating are talking to the judge, and so they see the judges and the judges see the student, but everyone else sees it from the side and from different angles or from behind, and you can't really see what's happening. Whereas when it's done online, all of the other students can see the same thing, so it's fairer. And the other point was that the students found it, the new skill was to stare at the camera, not stare at the faces on the screen, so you're not constantly looking around. It's actually easier because ideally you want to look at each judge that you're trying to persuade. And when you're doing it face-to-face, you have to look at the judge, look at the judge, and maintain eye contact with each one, be constantly calculating, oh, I haven't looked at that one enough, I need to focus on that judge more, I don't want to leave him or her out. Online, you just need to focus at the camera, and then all the judges get that direct line of sight. So they found that initially quite challenging, but eventually they thought it's much simpler and easier. I just stare at the camera now, and I don't have to worry about where I'm looking anymore. I'm looking at one place.
Professor Latayan, would you have any responses?
Yes, Professor Singh, thank you so much. So I would like to add to Professor James with respect to this question. So mooting as an activity is not only about speaking, but we are forgetting an integral part of mooting, the activity, which is also research and writing. Mooting also inculcates organizational skills, right? I mean, how to structure your arguments, how to present them in a better way, and also teamwork. So these aspects about the mooting activity, they are not going to be undermined during the pandemic. Definitely speeches and how you conduct yourself in the courtroom definitely is going to be impacted. But the fact that key takeaway from mooting is your research, your writing, your understanding of the law, those things are still going to carry forward. Those things are still going to be aided by mooting activities across the globe. And just to I remember this one incident, and this is very important. So these are the subtle differences that we need to understand that have happened now when we have shifted to an online space. I still remember, like, whenever, teams used to go for moot courts, they used to carry like one bag of books that they referred to. And the other bag of books was only to scare the other team that, see how much we have read. So all those things have now died down. I personally remember in my first moot, like it was a constitutional law moot, and I took the fattest book out of the library. And I was just like, flagging that book, not because I had read it, but because I wanted to show to my opponent that, see, this is how well I'm prepared. So those mental battles that can only be fought in a physical space, those mental battles have been diminished by online voting. But again, that being said, we cannot take away other key aspects of this activity that do add to a law student's life of being a professional.
I had a kind of a related question, and this question can go to Professor James and Professor Latayan again. So with the demand for technological proficiency from lawyers and judges in these times, should law schools focus on imparting technology skills as much as they do on promoting mooting skills in order to promote online teaching? So Professor Latayan, you can respond, and then Professor James.
Well, I kind of agree with this, but we need to understand the practicality of how much technology a lawyer needs to know or a student needs to know when they're mooting. So definitely they need to inculcate the new norms, the new etiquettes, the new mannerisms that you require to engage on an online platform. But yes, in addition to that, I would say that the soft skills, like for example, when you're arguing and suddenly there's a lag, right? You realize that your voice was not heard. Instead of panicking, those trainings are more important, because while arguing, it's the flow of the argument that matters the most to a speaker. And you might be thinking that you have made the most logical of points, but suddenly from the other side there would be a meek voice saying that, can you please repeat? And suddenly you find yourself, your flow is completely lost. And that is when the students panic, because they would feel that they have lost time, they have also lost on that good flow that they were building on. So I still feel that mooting as an activity needs to be reinvented. Technology is something, yeah, which is important, but more than technological training, it's still the mooting which should be in the center of online mooting activities.
I totally agree with Professor Latayan that apart from the technology, which is of course important and training is to be given, the substantive aspect of how to be a great lawyer, how to be a great judge, how to be a great jurist, which in all times, since time immemorial, we have inculcated, should also continue to be done, because we should not overestimate the importance of technology. What you argue on computer, on internet, is what you are. So what you are is far more important than, of course, technology. They are supposing you might be a brilliant lawyer, and if there is no internet connection, then that will not go through. But what you are basically conveying is what you are. That's why the basic requirements of being competent, being effective in communication, caring, all those qualities which we always inculcate should continue to be. And as Dean James rightly pointed out, it is not either or, that whether it would be online or person. The best combination would be both. Sometimes, of course, because of COVID, we are under artificial restriction. But once the thing normalizes, the personal touch, like the thing which I learned at Oxford on one-to-one level on tutorial, online that can be done, but that can't be done exactly. So the importance of personal touch, personal interaction will always be there, though at the moment, because of special circumstances, we are more dependent on technology than on personal interaction. So both training in training or technology and training in all those wonderful skills which are needed are to be emphasized upon.
Thank you, Dr. Singh. Professor James, a related question. To the extent that there is an unprecedented reliance on technology in these times, Can online mooting put certain sections of students at a disadvantage in terms of lack of equipment, technological knowledge, and connectivity? And what can schools do to address this divide?
I think my answer to that is yes and no. I mean, obviously, in order to participate in an online moot effectively, you need relatively good quality equipment and an internet connection. Otherwise, the issues that you flagged earlier around lags in streaming affecting the persuasiveness of the argument and low resolution, preventing the presentation of a persuasive case, all of those issues, of course, will come up. So yes, I think law schools, to the best of their ability, have an obligation to support their students to have access to at least the base level equipment that they need. But my view is, in fact, that the shift to online mooting has, in fact, expanded access to mooting opportunities rather than limited it. Because while, of course, getting good equipment is expensive, it's even more expensive to fly a team of students around the world to participate in a competition. And so what we've seen is that a lot of the competitions are larger because they're online, because there are more students and more law schools that are able to compete and participate. So I think that the shift to online mooting, whether temporary or permanent, is a positive move in that it has expanded access to participation in these competitions. And for that reason, it's a good thing.
One question I would like Justice McKenna to address is that, being on the bench, what kind of the qualities you would like to inculcate in students during these times?
I think so many things have been covered, but I agree, the lack of distraction and also knowing that it is just basically this space. So what are you going to do with this space? What tone of voice? How quickly are you going to speak? You really need to make sure what you are doing comes across well to the judges on the other side, whether it's moot or whether you actually come into court. Because I've been asked to do so many online things, just a couple practical things that I have been told. And that is the camera, it should be about this much of your body that shows. That the camera should not be below you, it should be above you. And you need to figure out, one thing that I really learned is that you need to figure out, where does your camera, as as Dean James has said, you need to be speaking to the judges. So I'm not entirely sure yet exactly where I'm supposed to be looking, where it looks like I'm straight ahead. But my camera, I have a webcam that is connected to the top of my computer. I thought looking into it made me look straight in. And I realized when I saw a recording of myself is that when I'm looking into my camera, I'm actually, it looks like I'm looking above. So I believe that when I'm looking at the screen is about when it looks like I'm looking straight on to people, I think. And I still have to figure this out myself. But the other thing is, yes, one additional thing I would say is for mooting, you're going to have a panel of judges usually. If you have a panel of judges, make sure you're on gallery view and not speaker view. Because at least while the other side is arguing, you can see the judges' reactions to what the other side is arguing. So you will still be able to see micro responses from the judges. You might see them frowning, or you might see them nodding or shaking their head, and you can see, or like furrowing their brows, like you can get senses. So make sure you're on gallery view instead of speaker view. And when you do speak, don't speak too quickly. Think about your tone and make sure that the judges can hear you. So practice that way.
Thank you, Justice. One more question for you. To what extent can online mooting be utilized as an opportunity to engage with distinguished members of the judiciary globally
Yes, as Dean James has said, I think I was recently invited to be a judge for a final moot for the National Asia Pacific American Bar Association. Unfortunately, the time conflicted with our own oral arguments, so I couldn't do it. But that final was connecting 9 state and United States federal court judges from around the country. Of course, in terms of time differences, we'd have to figure it out, but there's no reason it couldn't be done internationally also. And as Dean James said, because it was remote, there were so many more schools that participated this year as compared to past years. So in that sense, it did increase participation. And let me just say, this is a little bit of an aside, but because things are so remote now, for example, my son is a law student. He has actually visited Jindal in India, but he is a law student. And this summer, he was back home in Hawaii. He was supposed to be clerking for a New York appellate judge, Justice Cooper, who has actually spoken at Jindal on various occasions. But because of the pandemic, he was not able to go to New York, but he was still able to do his clerkship online from Hawaii. Now, the time difference made it that he had to wake up at 3 o'clock in the morning, Hawaii time, sometimes for hearings in New York. But there is no reason why some of these things can't continue globally. You can do remote internships also, not just mooting. I just wanted to mention that.
Thank you, Dr. McKenna. Professor Latayan, perhaps this question can go to you. This is a question now from the audience. This question says, mooting and trial advocacy being integral to the curriculum in law schools demand hours of research and practice on the part of students. A variety of books and reporters are required for preparing memorials and compendiums. However, since the pandemic hit, students have not been able to access libraries, and the online database does not seem to replace what the campus library has to offer. So what resources can you provide to these research, their ability to research and to participate?
Well, that's true, and you can't really replace a physical library or that physical space where you're surrounded by books. But definitely to have a robust online mooting culture in institutions, online resources are the need of the day right now. You need books, you need reporters, you need journals, access to journals online, so that students their preparation is not hampered. That's actually correct. But in addition to that, having said that, there are limitations associated with physical access as well. So I mean, navigating through a 1,000-page book is much more difficult when you have the book actually in your hand than when you have computer in front of you and you have an online version of the book. Features like control Fing, finding specific words in the books, those things are also some things that add to the convenience of the whole exercise. So yes, but that's true, and I agree with it that at times, because law has such it has endless possibilities. There's a dearth of material on every topic, even though that topic has been written over and over again for thousands of times. But yes, I mean, perspectives matter. You need to read different authors. You want to know how many different times a particular case was argued, cited, how many times it was not relied upon. All those things definitely they come from resources, physical as well as online. So yeah, online libraries, online research, databases, they need to be available to students to actually make online mooting a success. I completely agree with that.
Professor James, any comments?
Yeah, I just want to pick up on a point that was made earlier about how the fact that the shift to online mooting doesn't change a big part of the mooting experience, which is, of course, the preparation. And the COVID pandemic has in fact forced our students to rethink the way in which they collaborate and prepare for MOOT. So in addition to, the shift to accessing electronic resources that Professor LATAYAN was just talking about, just the way in which the students interact with each other. So traditionally they tend to lock themselves in a room for 3 months and work together in a physical space in preparing for the MOOT competition. But because our students were scattered all over the country at the moment, our students were working together still very closely for hours and hours at a time, but via their devices, via WhatsApp, by Zoom. And last night I got to speak to some students who performed very well in a competition. They never met each other in person at all. They were in 3 different locations around the country. They prepared, they participated in the MOOT, they performed extremely well, and they still hadn't ever physically met each other. And I think that's the kind of benefit or advantage that isn't going away anytime soon.
So just to add a point there, and this is fascinating. So the level of team play that is like involved in online mooting is something which needs to be understood, and it needs to be inculcated. People without meeting each other are a team, and they work together, they assist each other. That is a big takeaway from online mooting exercises that students need to inculcate and develop upon. I mean, being a team player and working in a team is a great ethic to acquire out of this experience of online mooting.
Professor LATAYAN, so just to carry on from this point, there is a question from the audience which says participants in online moots find themselves sitting in the warmth of their homes or comfort zones and may not carry the true spirit of arguing and presenting before a court of law against another counsel. How do we address the probable dilution in values and ethics due to a lack of physical proximity, which would otherwise be followed by mooters?
Well, this is an interesting question, and I want to develop upon this point, which was initially made by Professor James and then forwarded by Justice McKenna. So the window in which you are seen has reduced, and hence the ethics, the mannerisms are now limited to this window. Earlier, so for example, when you go to a court, you are all dressed up. You wear your robes, you wear your trousers, and you wear your shoes. But now on the online platform, the shoes aren't visible. So definitely, if the question hits on the point that students may not feel obligated to dress completely from head to toe, yes, that's true. But when mooting, I don't understand how it dilutes your rigor or your enthusiasm, because even though so even if I'm going for a moot today and I'm told to speak, I would be as passionate about my case as I would be in a physical court. And as Dr. Singh also mentioned, it's the person who's arguing than the platform on which the person is arguing. So if you are if you have the zeal to argue, you can argue even in your sleep. So that is what I feel.
Just adding a point to Professor LATAYAN. When a person like Kapil Sibal or Mukul Rohatgi argue, even online, one can make the difference that how different they are than an ordinary lawyer. One more point I will add on this mooting is that mooting is for the purpose of becoming effective lawyer. So it cannot be substituted for actual experience of the court. So I would strongly recommend that internship, and it is, as Justice McKenna said, it is possible to have the internship anywhere in the world. So this opportunity of having internship with some of the greatest lawyers, some of the greatest judges is an opportunity which students should take, because now it is possible. It may not be possible when things get normal.
This is again a question from the audience. It says the traditional method of mooting offers an opportunity to understand court manners and etiquette to be followed by a lawyer. Imbibing these skills becomes challenging for the learners in the online mode. How do you think this concern can be overcome while engaging in the online platform?
That is a very good question. That's true. The courtroom etiquette in terms of entering, where you seat, how you stand, how you address the court. But there are things that are still the same in terms of how you address the court, how you speak, your intonation, how you respond to questions. there are certain things that are just so the same. So I would just say that, and I do, as I said before, I believe that online may continue for certain types of cases. For example, I believe we will now continue doing online remote oral arguments when we have a judge from another island, or perhaps when we have attorneys from other islands. So if they don't want to travel, we can just do it online. And for some minor traffic cases, we can do it online. But for regular cases, I believe as soon as this is over, we're going back to regular court. So you're going to be able to learn the court etiquette. I do not see us going completely online. It'll just be certain types of cases in certain situations. So you'll still have the opportunity to learn courtroom etiquette.
Thank you, Justice McKenna. Raj, would you like to sum up?
Thank you very much, SARBANI, for so skillfully and nicely chairing this session, moderating the panel. I deeply appreciate your comments and reflections on this, because, you know, when we put together this conference, we were conscious of the fact that we want to dedicate a few panels with a focus on students' interest, where students could directly resonate with the kind of discussion that we're having in this conference. This is one such thematic session. I am particularly grateful to all of you, Justice SABRINA McKenna, Dean James, Dr. Surat Singh, Karan, and of course SARBANI, because so many points and perspectives that you shared will lay with the students' mindset as they think about mooting and advocacy. But it goes beyond the online dimension. Online is more, or physical is more, a tool. The idea of mooting is so integrally connected to advocacy and articulation. And I really enjoyed the panel, and I deeply appreciate your presence. Thank you very much for your time. Be safe. We'll have a short break, and we will move into the 22nd thematic session on role of regulatory bodies and courts during the pandemic. We will have Honorable Justice Arjun Sikri, International Judge of the Singapore International Commercial Court, Professor Pip Nicholson, Dean of the Faculty of Law, University of Melbourne, Professor Vijay Kumar, Vice Chancellor, National Law Institute, Bhopal, Honorable Mr. Justice Michael Wilson, colleague of SABRINA in Hawaii, and chaired by Professor Sudarshan, Dean of our Public Policy School. Thank you very much. I look forward to all of you.
Thank you.